Hello, everyone. It is a great pleasure to warmly welcome you to this session, season 2 of the online engagement session of the Transboundary Freshwater Security Governance Training. My name is Yumiko Yasuda. I'm the Senior Transboundary Water Cooperation Specialist at the Global Water Partnership and the lead faculty of the Massive Open online course on governance for transboundary freshwater security, which was developed by GWP GFIW Learn, along with many global partners and experts from the field of transboundary water. Since opening of this course in August 2020, this MOOC has attracted 2,500 participants from 152 countries around the world, confirming the need and interest of learning about this subject. The course is available for anyone to take at their own pace. And I'm also very happy to inform you that originally course was supposed to be ending at the end of August this year, but we have extended it for one more year until August 2022. So please feel free to join if you have not yet done so. In order to enhance the learning experience and to provide the opportunity for people to engage and interact with experts in the field, GWP and the Wuhan International Water Law Academy worked together to create an online event series called Transboundary Freshwater Security Governance Training. We had a very successful series of 6 events from January to June this year. And now this autumn, we are starting this season 2 of this online series. In this series of events, we'll be highlighting not only the key topics of transboundary freshwater governance, but also to highlight the various examples and expertise from different geographic locations around the globe, as if the train is stopping at the various locations in the world. In this season 2 of the online sessions, we have planned for 3 events. This September, in October and November. You will see the different topics that we are planning on the screen right now. Today is the first session of this season 2, and the topic will be on the international water law and the dispute settlement. Today's session has 2 main parts. The first part is a panel discussion by distinguished speakers, where they will be sharing their experience on the topic and answering your questions. The second part is a breakout session where you will all have opportunities to interact with experts. We have a great lineup of session chairs and speakers for the next 1.5 hours. And today, our transboundary freshwater governance train will be stopping at Asia, Europe, and Latin America, welcoming speakers from all of these regions. We have several housekeeping rules for this event. This online session will be recorded so the people who couldn't join due to the other commitments or the different time zones will also be able to view the discussions. Please always mute your audio when the moderators or speakers are presenting. You can unmute your audio or will be invited to unmute your audio by the moderator if they are requested to do so or during the breakout session. This event will not only present a new knowledge, but will also welcome your inputs in the interactive sessions part. So we count on your presence throughout the whole session. Today's session is designed to be as interactive as possible for you to be able to ask your questions to experts and also provide your thoughts and feedback to the subject. We'll be using the poll if as a main interactive tool, particularly during the first session. While we are waiting for the event to start, some of you have already used the poll if. So let's see now the poll if screen. Now, we ask you a couple of questions now here. So my first question is, how many states have accepted adjudication by the ICJ, International Court of Justice, for any dispute arising under the UN Watercourses Convention, conventions compulsory when not resolved through the negotiations? So for those who are not the legal experts, the wording might be a little bit difficult. The adjudication technically means that it's a legal process of resolving a dispute. So basically, this question really means that how many states have agreed for the ICJ, International Court of Justice, to resolve their disputes that have not been settled by negotiation. So we give you some moments. A lot of answers here on the D, less than 5. We still also have people answered yes to more than 50 states, more than 20 states. Okay, this is quite a key question that you will hear more about this from our speakers. Now, more and more people are answering to say more than 30 and 50 states. Okay, let's see the correct answer. The correct answer is D, less than 5. And in fact, there are actually 3 states who are in this category, Hungary, Montenegro, and the Netherlands. So thank you for answering. Let's go to the next question. Is adjudication by international court be preferred over other type of international dispute settlement, such as negotiation, good offices, mediation? So this is more or less a question asking your opinion. What do you think? Is adjudication, which is the adjudication by international court, to be preferred over other types of international dispute settlement, such as negotiation, good offices, mediation? So is ICJ or other mechanisms? This is the question. Yes or no? It seems majority of the people are now answering no. It's not preferred over other types of other ways. So maybe people prefer to have negotiation, mediation, and so on. 20% of people are saying yes, we support more preferred methods to be this International Court of Justice. So this is actually a question that you could ponder while you listen to our panel presentations and discussions, and perhaps you could also come back to that while you are also in the group discussion later on. So thank you very much for answering this question. Let's go to the next one. So this one is an open question for you to type any questions that you would like to ask to the panelists. When you registered to the event, you have submitted some questions, and we are actually taking into consideration those questions during the panel discussions. You can, of course, type the same questions, or you can type new questions. And you can also vote for the question, because some of other participants may type questions that you also want to ask. In that case, please vote. And during the panel discussion, we try to take into consideration your questions and the popular ones as much as possible. And this poll will be open during the whole event. So you will be able to actually type in the questions as you hear the presentations, and some questions might pop up. So please feel free to keep this page open and type your questions. I don't see anybody typing the questions yet. Yes, I see it now. What is the best dispute settlement for Trans-Boundary Water Corporation? That is one. Thank you for the question. So please keep thinking about if you have any questions. Type it in. If you like it, please vote. Okay, now we see is fact-finding important? How do you assess the effectiveness of the ICJ in resolving water-related disputes and so on? Which transboundary river has many conflicts and how has it been resolved? So these are really, really interesting questions. Thank you very much. So please keep typing and keep voting. So let us move on to now introduce the main part of today's session. And here I would like to introduce two distinguished event chairs today, Professor Otto Spiers and Dr. Patricia Wouters. So Professor Otto Spiers He is a founding staff member of the International Water Law Academy and also professor at the China Institute of Boundary and Ocean Studies and the Research Institute of Environmental Law of Wuhan University. Otto studied at international water law at the University of Amsterdam and New York University of School of Law and the Hague Academy of International Law. He also studied philosophy of the University of Amsterdam, University of Malta. And prior to joining this International Water Law Academy, he was a lecturer at the Public International Law at Utrecht University and a researcher as well. And then you can see a number of his achievements here. But the most important thing here is the fun fact that Otto now recently got a Chinese name. And you can see on this screen, it says Kao Hai Pi. The first letter means high, the second letter means the ocean, and the last one is flat or the peace. So this name is inspired by his height. Otto is very tall, and the fact that he was born near the ocean. Very, very relevant name, also for his profession as well. His biggest achievement in life is finding a home in lots of different countries. And that's an excellent skill to have, I must say. And I would now next like to introduce Professor Patricia Wouters. He's a founding director of Wuhan International Water Law Academy at the University of Wuhan. And Professor Wouters has close to 30 years experience in the field of international law and governance of transboundary waters. And Professor Wouters also published and consulted broadly on international water law, including the UN, the World Bank, regional bodies, and national governments across. She's also a founding director of the University of Dundee UNESCO Center for Water Law and Policy and Science. And she established China International Water Law Group, the Xiamen Law School, and where she was appointed under the Chinese Thousand Talent Program. The fun fact is that Patricia has a dual nationality, Canadian and Belgian, and lives mostly in Scotland and commuting to Wuhan. I'm not sure if these days she's able to commute, only virtually perhaps, but definitely, hopefully this will happen soon. So the biggest achievement that she has in her life is her healthy family. So with this note, I would now like to hand over to two distinguished chairs, Professor Otto Spiers, Professor Patricia Wouters. The floor is yours.
Hi. Do you want me just to start, Otto? Yes.
Yes.
Okay, good. Well, I'm so excited to be here. Yumiko, thank you so very much. And thanks to so many people. Thanks to the GWP team. Thanks really to Alistair Rue Clark and Barbara, who pioneered the International Water Law module for GWP. Thanks to the fantastic speakers today. I'll go quickly so that we can listen to them. Thank you to our regular attendees. I recognize many of you and lovely to see you back. Hope we can get you to Wuhan sometime soon. And I'd like to name check. We have two new graduate students starting at the Academy in Wuhan. So well done to those two students, Jean-Luc and Otto. I'm happy to see you here. I am going to give you a very quick and brief summary of what dispute settlement is in international law and what it is in international water law. Next slide. Please, Lisa, thank you. We start with, from a public international law perspective, and I always like to look at the Charter of the United Nations, and all of my students will know that I require them to have a Charter of the United Nations because we are doing public international law. And if you look at Article 2 of the Charter, it says all members shall settle, so an obligation, their international disputes by peaceful means in such a manner that international peace and security and justice are not endangered. So we have this overarching duty to settle our disputes peacefully. The second area that we can have a look at in the Charter is Article 33. And Article 33 sets out an indicative list of methods that we use to resolve disputes: negotiation, inquiry, mediation, conciliation, arbitration, judicial settlement, regional agencies, or other peaceful means. So that's the context. Next slide. So what we need to take away today is that there are three fundamental principles of international dispute settlement. One, it must be peaceful means. Two, requires consent of state parties when you're selecting the means. And three, there are a broad range of options for resolving disputes. And I'd like to thank Anna Maria Daza-Clark from the University of Edinburgh, who shared some of these slides. She made a presentation on dispute settlement and agreed that I could use some of them. So here's one of them. I like that we've shown a progression of dispute settlement mechanisms. So we start with diplomatic means where we have no third party. So if there are differences or tensions between states, we start really with consultation, negotiation, political or diplomatic moves where disputing states will try to resolve their disputes without a third party. If that can't be done, then we move to diplomatic means which involve a third party. So we are talking about mediation, good offices, conciliation, and perhaps fact-finding. And this is where the states will agree to involve a third party while helping them to resolve their disputes. It's still largely diplomatic, and the outcome is generally non-binding. That doesn't work. And if the parties agree, then we can go to jurisdictional means of dispute settlement with more binding effects. So that would be before the International Court of Justice or through a court of arbitration. And here the parties have to consent to bring their dispute to a third party tribunal, institutional or ad hoc. Okay, next slide. I just wanted to summarize quickly the diplomatic means, and you see I've noted here that all of these require consent. Dispute settlement and international law, sovereign nations have to agree to do this. So what can they agree to do? They can agree to use good offices, where you get a third party as a go-between. That can be an individual, a neutral state, an international organization. We saw the World Bank play this role when we negotiated and concluded the industry between Pakistan and India. You can have a mediation where you have a third party that you invite to facilitate a negotiation. Someone who is independent, doesn't take sides, helps to bring the parties to the table to mediate an outcome. And then conciliation. Conciliation is a step forward from mediation. It's where the third party has a more active role and tries to involve the parties, say, in fact-finding. And it's a method that's used in the UN Watercourses Convention. A third party suggests the terms of a settlement. So a conciliator really leads and controls the process and helps the parties to find an agreement to their dispute. In all methods, the outcome is not binding on the disputing states, although they can sign up to do any of these. Next slide, please. Finally, the International Court and international arbitration requires consent. So I hear, a lot of students ask, countries ask, what can I take another nation to court over this? I want to go to court or arbitration. Well, you can't. You can't unless you have consent. Arbitration generally has more flexibility than adjudication going before the International Court of Justice. In arbitration, generally the parties appoint the arbitration, and the arbitral tribunal generally devises its own procedural rules. The decision is generally private and closed, generally binding on the parties, and there is no appeal mechanism. We see arbitration used a lot in international economic law, but also in public international law. Adjudication, generally, we talk about the International Court of Justice. The parties are not free to appoint the judges, although they can name a party, a judge from each of, on behalf of each of the countries, but there is a panel of judges already sitting at The Hague. They have set rules of procedures under the statute of the International Court of Justice and rules of procedures. The decision is binding only on the parties. There is no precedent in international law, and there's no appeal mechanism. And Professor Lingji will tell you about this. Next slide. Now, I'm just going to quickly say that the UN Watercourses Convention, in its Article 33, has adopted a provision that we refer to as compulsory fact-finding. If the parties have gone through all of the other means, if they, tried negotiation, they've tried mediation, they've tried any other means, and there's still a dispute, then parties to the UN Watercourses Convention agree that their dispute shall be submitted at the request of any of the parties to impartial fact-finding. But we've heard today that the only parties that are Hungary, Montenegro, and the Netherlands. There may be other parties caught in this, but it was compulsory fact-finding and conciliation, conciliation that really will be help the parties to find a solution. So that's one formula under the UN Watercourses Convention. Next slide. Now, I'm not going to go through these next 3 slides, but I want to thank Anna Maria Daza-Clark again. We've got a summary of state practice, treaty practice, where different means of dispute settlement have been agreed to. So we've got the UNEC Water Convention, the 1992 Watercourses Convention, the Mekong Agreement that talks about mediation, the Almaty Agreement on the Aral Sea talks about third-party involvement. The Indus Treaty differences go through a neutral expert, and it's actually resulted in neutral experts being appointed on a couple of cases. The Sava River Basin Agreement, third-party mediation or conciliation. Next slide. I'm not going to read all of these. So you've got the Indus, the Almaty, the Rhine Convention negotiations, ZAMCOM. The Rhine Convention also has an interesting compliance mechanism. Next slide. Next slide. Going the next, Lesotho Highlands Water Project, the Rhine Treaty. Next slide. I leave those slides for you to look at, and you can ask me questions on them later, but I wanted to get to Professor Kung and the speakers. So in summary, what you need to know about international dispute settlement applies to international water law dispute settlement, should be peaceful, requires consent of sovereign nations, and there's a range of options and state practice. That's my presentation. I will welcome any questions, but probably the experts will build on this. Thank you very much.
Thanks very much, Patricia. So it's my speakers. So I will introduce all 3 of them in the order in which they will present, and then immediately I give the floor to the first of the speakers. I must say that I'm speaking to you from Wuhan, from China, and today is actually a public holiday in China. It's the Mid-Autumn Festival, in which people, they sacrifice little cakes, cookies to the moon, the celestial body. But nowadays, it's my understanding that instead of sacrificing the cakes to the moon, people rather eat them themselves, which I think is a very clever innovation of this tradition, or they give them to each other. So people today, they give mooncakes to each other all the time. So Ling Chi Kung is the first one to speak. He's a professor of international law and associate dean for research and international cooperation at Wuhan University. So he's actually a colleague of mine, and he will also be speaking to you from this wonderful place, Wuhan, where I'm also at the moment. And he will give an introduction to the international water law dispute settlement mechanism. So he will just provide us with a tour d'horizon, an overview. And then I'm very happy to be able to present to you 2 other speakers that are actually involved in litigation before the International Court of Justice in cases relating to transboundary water issues. So that is quite unique because there's not that many cases currently pending before the International Court of Justice that relate to transboundary freshwater issues. So the people that are now attending this webinar, and we have over 100, they should all feel very privileged to be part of this. So the second speaker is Jimena Fuentes. She's an associate professor of public international law at the Faculty of Law of the University of Chile. And she's also agent for the Republic of Chile before the International Court of Justice in the dispute relating to the Silala waters. And she will also be talking about this very dispute. So she's not a professor. Well, she is a professor, but she's mainly a practitioner. So she knows this case better than anyone else in the world, I guess. Her fun fact, I really want to mention this, is that she was actually a TV star in a national television's children's show called The Flying Coffee Maker. I find that fascinating. So maybe in the breakout room, we can interrogate her on this as well. And then the final speaker is Gabriel Baranyay. Yes, there he is. He's a senior lecturer, you see it there, at the National University of Public Service in Hungary. But again, maybe more importantly, he's also an ambassador that is who is representing his country, Hungary, in the dispute that it has with its neighbor relating to the Gabčíkovo-Nagymáros project. This is a case, well, actually the International Court of Justice already delivered a judgment on it long time ago, but formally it's still pending, but he will explain this in more detail. And he has 4 children. I don't know what's funny about that, but that's his fun fact. He has 4 little children. So I now give the floor to Professor Kung Lingji. You have 5 minutes, and that's a very strict time restriction. I apologize for this in advance.
Okay, thank you, Chair. Thank you, Professor Otto Spiers, for your kind introduction. And I would like to start by saying happy Mid-Autumn Festival to you all. It's a very important Chinese traditional festival for family reunion. I also would like to thank Patricia Wooters, my colleague, for setting the theme by introducing the basic principles and the means for international dispute settlement. You know, for international lawyer, when we talk about dispute settlement, we cannot, you know, we often go with the UN Charter. So the thing is that I would like to spend 5 minutes on the major cases. So when you look at the first slide, you can see some of the cases are quite old, like the River Otto case. Some are very new, like Otto just introduced, the Silala Waters case, which is currently pending before the ICJ. And some of the disputes were submitted to the Permanent Court of International Justice or its successor, the International Court of Justice, which is the principal judicial organ of the UN. And the other cases were submitted to arbitration. Next slide, please. Yeah, when we look at the subject matter, we can see they can be broadly categorized into the following category, like river boundaries, or even the definition of transboundary water, meaning that whether the water itself is transboundary or international. There can be cases concerning navigational uses or non-navigational uses and protection, which now getting more and more popular in the cases before the court. Next slide. For lawyers, what is more important is the applicable law, because when we look at the cases, we do not only look at the fact, we look at the law. The law applied by the adjudicators can have far more important implication for the future. So for the cases, it can be categorized into the following groups, like the court adjudicate solely by the treaties, you know, like special agreement, the Watercourses treaties concluded by the parties. They can interpret some of the relevant provision of the treaty in light of customary or general international law. This is very, very important. You know, although they are interpreting a very special treaty, but they have to interpret the treaty by international law. And then they probably adjudicate solely by general international law. For example, in the Costa Rica and Nicaragua cases, the 3 cases, you know, and also the Silala Waters case, perhaps the court should also adjudicate the status of the waters by general international law. And sometimes they also interpret and apply the provision of some other very important multilateral international treaties, like the Ramsar Convention, the CBD, or the ESPO Convention. Next slide. Now moving on to the legal question about the case law. This is really important. I mean, when you talk about the case can be, very specific in terms of fact and law. But when we talk about case law, when we talk about jurisprudence, we look at concrete legal questions. So all the cases that have been settled or pending before the court concern the following questions, following group of questions, like the definition of international watercourse. What is a watercourse? And can you move back? Yeah. There are also some cases concerning the basic principle of the law of international watercourses. Some of the principles you are very familiar with, like equitable and reasonable utilization, but you do not know exactly what they mean or how they can apply. But when you look at the case, you can see, oh, this is how the adjudicator understand this principle and translate the very basic principle into concrete rules to settle the dispute.
Yeah, you see, Kong, you do have 1 more minute left. Thank you.
Yeah. It can also concern the rights and obligations of the watercourse states, like, for example, the procedural obligation of notification, consultation, or carrying out environmental impact assessment. And when some damage alleged or caused to the watercourse states, that may concern the state responsibility, reparation, and compensation. Next slide. So let me end my presentation by citing Article 38 of the ICJ statute. When you look at this article, you can see, especially paragraph D of this article, subject to the provision of Article 59, the judicial decision is a subsidiary means for the determination of rule of law. So which means it is very important sources of international law, apart from treaties, international custom, or the general principles. But it is subject to the provision of Article 59, meaning that the judgment, the judgment and the award or orders are only binding upon the party to the case itself. So thank you, Otto.
Okay, great. Thanks a lot, Lingji. So without further ado, I would like to now give the floor to Jimena. Jimena, please, you have the floor.
Thank you very much, Otto. Thank you very much, Patricia. Thank you for the invitation and thank you to all the organizers for this great job with the organization. Well, as Otto has already said, I'm here in my capacity as a law professor because despite the fact that Otto said that I am not an academic, in fact, I am an academic. I'm only in my spare time, I am agent for Chile in the Silala case. So I come from academia. In fact, I wrote my PhD thesis on international watercourses, which was something that in the end proved very beneficial because we have now all these water disputes between riparian states. At that time, when I was writing my thesis, the United Nations, the ILC were discussing the draft articles on the Watercourses Convention on non-navigational uses of international watercourses. Okay, next slide. So I would like to speak today really a very general description of what is the Silala dispute about. So here you have a map of Chile and of South America, and there you can find Chile, which is a very long and thin country in the west of South America, and Bolivia, that is on the north of Chile. Next slide. And here you find a map where you can see the Silala River basin. The Silala is an international watercourse that has its origins in Bolivia and then crosses the boundary to Chile and forms part of a bigger basin. There you see Rio San Pedro, which in the end goes into the Rio Loa, which is the largest river in the northern of Chile. And in fact, you can see that Chile in the north is very, very dry. There you have the Atacama Desert, which is the driest desert in the world. Therefore, water here is very, very important for the development of this area. Next slide. So here you have a satellite image where the yellow line is the boundary between Chile and Argentina. And you can see that the Silala, the water comes from Bolivia. The origins are there, just at the edge of the lava remains from a volcano to your right. Yes, there you can see a little bit of green because there is a very small wetland over there. And then the water comes to Chile because of the topography of the terrain. So water comes down. And in its travel through this desert, the Silala has built really a ravine. So you can see there how the ravine is cut in the territory. Next slide. So here you see the Silala is very small. However, water in the desert is like gold. So even if this is very small, it has been very important for the development of the Chilean desert and for the small towns that were founded in this very dry area. Next. So here you can see the ravine and the water and the vegetation that is even inside the river, you see. Next slide. So some basic facts. Here you can see that this river was used by the two countries at the beginning of the 20th century. The first water concession was granted by Chile in 1906 to a private company called the Antofagasta Chile Bolivia Railway Company, which at that time required water for the engines. And in 1908, Bolivia also grants a water concession in its territory to the same company. And after 100 years almost, Bolivia terminated the concession granted to this private company in its territory. And only it was in 1999 that Bolivia was the first time that denied the status of the Silala as an international river. Next slide.
Yeah, Jimena, I'm so sorry, but we have about a minute left. So still enough time to get through this. This is fascinating. Thank you.
If we could go to the next slide. Okay, so here you have the procedural development. You will have this slide next. I think that you will have copies of these slides, but here you have the procedural developments. So as you see, the written phase of the proceedings have ended. On September 2019, Chile submitted its final written pleading. So we are waiting for the oral pleadings now. Next slide. And originally, the dispute was about the status of the Silala as a watercourse. So in fact, this was a sort of a question about facts, you see? So Chile requested to the court to say that the Silala is an international watercourse. If it is an international watercourse, then the rule that governs the use of this watercourse is equitable and reasonable use. However, the case today is somehow different to what it was originally. Next slide. And the next. And the next. Okay, so today here we have that things happened. First, Bolivia recognized that the Silala is an international watercourse. However, Bolivia's case, which is in its counter memorial, is very interesting because Bolivia, what is Bolivia saying today? Bolivia says, okay, it is an international watercourse, but the private company made some waterworks, and those waterworks have had an impact on the river. The impact, according to Bolivia, is that there would be some artificial flow, that is an extra flow of water. And then Bolivia says, and over that extra flow, Bolivia has sovereignty or property. So that is the case about today. I think it's very, very interesting, and we can discuss this further in our meeting today. Thank you.
Great. Oh, great. Thanks very much, Jimena. Yes, 5 minutes is very short. And now I give the floor to our final speaker from Hungary. Gabor, you have the floor, please.
Okay, thank you, and hello to everyone. Unlike Jimena, I'm a full-time diplomat and a part-time academic, so I may just look at this case somewhat differently. I've been actually involved in this case since 2004, which is only the half time of the dispute. So as Otto mentioned, this actually has been the longest pending case before the International Court of Justice. It's still formally in the docket of the court, and it's still unresolved. So I try to shed you light on the evolution. So can we have the first slide, please? Yes, basically just a few facts, and maybe we can move actually to the next slide, which is a map. Yeah, so the whole project officially started in 1977 when both at the time Czechoslovakia and Hungary were two communist countries, which is important because this was somewhat a top-down imposed project by the Soviet-run Comecon, that was sort of the economic cooperation body. So both countries had limited sovereignty, and even at the time, you know, they were driven by the so-called hydraulic mission, so that, you know, nature can be conquered and nature must be conquered for the benefit of, you know, economic development or producing more steel for tanks and those kind of, you know, noble ideologies. So basically the project the project involved the development of two particular dam systems, one in Czechoslovak territory, which would have gone or utilized the waters of the joint riverbed. So basically the river was the border that should have been diverted to Czechoslovak territory, and one strictly on Hungarian side. You can see the one on the right hand side. That's for the Hungarian dam, and the other one near Gabčíkovo in Czechoslovak territory was the upstream part. What happened, and can we have the next slide, please? Oops, that's a bit running ahead. Can we have the slide after the map? Because we have big questions. Yes. So basically, this project got delayed and delayed because there was not enough money. So both countries got to various different stages by the early 1990s. And this is extremely important because this is when communism fell in both countries, But by the time, Czechoslovakia was very well progressing with its own part, and Hungary did hardly anything. And just because it happened that these two dams were about to destroy, and actually partly destroying, two of the most important natural areas of the country, Hungary, due to the change of winds in politics, decided to pull out from the whole project. And in response, to the sort of uncompromising attitude of Hungary, Slovakia put the dam into operation and diverted the Danube. That happened in 1992. And as you can imagine, if you divert 40 kilometers of the second biggest river of Europe from the joint riverbed, that's going to cause a problem. So the two countries accepted, based on EU pressure, actually accepted the referral to the International Court of Justice, which actually delivered this judgment in 1997. And what is also very important, that in 1995, there was an interim agreement between the two parties, which partly solved the allocation problem. So before that, Slovakia took 95% of the common water. After that, only around 20%. So we have the judgment from 1997, and can we move to the next slide? And basically, this is a very, very widely quoted judgment because it fixed a lot of, fundamental problems of international law. But what it really didn't fix was the dispute. And that's very critical, because basically it said, Hungary was wrong on this, Slovakia was wrong on this, and there was a list of questions. But sometimes, the court made very contradictory statements in the very, very long judgment. And basically its main message was go back and negotiate in good faith. And can we move the next slide?
Yeah, we just have under a minute left, Gabriel, but I see you're finishing. Thank you.
Basically, since 1997, negotiations have been going on and off. Again, I've been involved in this since 2004. It's a very painful, slow-moving process, but as probably in other cases, there was a flashpoint. There was a period when tensions are high, and normally when you pass that flashpoint, the desire to settle these problems just diminishes, and in a way it's got into a phase of an acceptable sort of frozen conflict, where none of the states are happy to put up a very big fight just to make of it. But of course the case is still open and we're still negotiating. So thank you very much for your attention.
Yeah. Thank you very much to the three speakers. So we now have some time for questions, and these questions, I'm not going to come up with them myself, but I actually wanted to ask the questions that you guys have suggested. First in the poll, Eve, that is when you registered, and then now also we have received some questions that you have raised in the chat. So I will begin with the questions that we received upon registration. I will just ask the question to Lingji, and then a question to Jimena, and a question to Gabor, but I will begin with Lingji. What is the most effective dispute settlement mechanism in the settlement of transboundary water issues? So the most effective dispute settlement mechanism.
Hi, Otto. That's a very, very good question and a very important question. But most of the time, when you ask somebody what most effective, you have to define what do you mean by effective. If you ask a married man, like 100 married men, about how to effectively settle differences with their partners, they have 100 different answers. And the same, I think, apply to disputes concerning transboundary waters. So, for example, if you want all the differences avoided, you probably need to set up something to avoid the dispute before they arises. For example, you probably need to set up some institutional mechanism for coordinating your interests before they turn or escalate into a real dispute. When you have the dispute, you do not want the dispute to escalate, to aggregate, then probably you need to find a better means for conflict management. For example, you should give the joint body the task of controlling and managing the conflict. And then as a lawyer, I would always say, before you go to the court, you probably need to be prepared. You cannot just leave the case to the lawyers, you know. You have to be prepared with the evidence, with the result. Probably you cannot think about what you can get, what you can achieve, you know, very positively at the end of the day. You should think about the worst outcome you cannot bear, like if I lose this, I cannot live, I cannot survive. Then go to the court. But think about it, that'll be your neighbor, you know, you'll be living forever with that neighbor. If you bring the case, go to the court, have a suit, you know, the legal proceeding, at the end of the day, you get a judgment and the court cannot enforce implementation. It has to be implemented by the parties. So I think I have talked too much, but that's my answer. You know, there's no answer. You think very carefully and make a very wide decision for conflict avoidance, for dispute management or dispute resolution. Thank you, Otto.
Yeah, that's a very comprehensive answer. Thanks very much. Then I wanted to ask a question to Jimena. So how are disputes settled relating to significant harm that is allegedly then caused by the upstream country to the downstream country, and what's the role of dispute settlement? You have the floor.
Thank you, Otto. Well, I think that the first thing to tackle regarding your question is, what is harm? What amounts to harm? And here we have an interesting debate about the relationship between the two basic rules of international watercourses law, which is the no harm principle on the one side, and on the other, the reasonable and equitable use. So disputes about allocation of waters between riparians usually is not a dispute about harm. However, when you talk about pollution or other environmental detrimental effects, there is a tendency to look at the dispute about the application of the no harm rule. So the question is whether these two rules are separate. I think that from an environmental protection perspective, we could say that the rule of no harm tends to operate as an independent rule, because now we have principles that have developed in the field of environmental protection. But with regard to water allocation, I think that the best way to tackle those controversies, those disputes, is by application of the rule of reasonable and equitable utilization. Now, coming to your question about the relation between upstream and downstream states, upstream states, they have more chances to impact downstream states than vice versa, you see. So the problem is that upstream states are in a position where they have a control of the situation. They can simply act and then have an impact on the downstream state and negotiate later. So it will be a situation of a fait accompli, in fact. That puts downstream states sometimes in difficult position. So there, I think that the answer to how to solve those disputes is in the procedural rules. It's good that now upstream states have to notify, have to consult with the co-riparian if there is a chance to affect them. And also the fact that now we have this obligation of conducting a transboundary impact assessment. So that would be my answer, Otto. Thank you very much.
Yeah, thanks. This is a big debate in international water law scholarship, the relationship between the equitable and reasonable utilization principle and the no harm principle. And I see that Gabriel Eckstein is in the audience, and I know he has some very specific views on the relationship between those two. So I look forward to discussing this with him in the breakout sessions. I kindly encourage him to express his views. So now I give the floor, I ask a question to Gabor. This is an interesting one, I think. How can old and outdated watercourse specific agreements be updated, especially in response to changes in demographics and population? I find that interesting question. I don't know if you have a particular view on this.
Yes, thank you. I think it's a very interesting question. If you try to put it into context, I think it's all about allocation. I mean, why would you consider, rearrangement of an old agreement unless, the circumstances have changed in the riparian states? And probably the answer is that I don't know. I mean, for sure. I mean, historically, water conventions have been based on have been negotiated on the basis of territorial sovereignties, and all the principles of international law evolved along, these things, and where pretty much the fact that how much water you need and what kind of water resources you have at your disposal didn't come, into play very much. And apparently, we do have the UN International Watercourses Convention, which makes a very sort of scant reference to vital human needs when we interpret the reasonable and equitable utilization rule. But to my knowledge, that's how far it goes. So I actually certainly I live in Europe, and we deal, with transboundary water issues under the umbrella of EU law, but this kind of consideration hardly ever, comes into play. Partly because there aren't significant changes in populations in the EU, and certainly there aren't very many transboundary water allocation treaties. Actually, it would bring, this whole dimension would bring, or whole question would bring a new dimension into the structure or the deep foundations of international water law, which I think it may be timely in many parts of the world, but until now this hasn't really been the case. So unfortunately, I don't have an answer. All treaties, are renegotiated based upon political initiatives, and if you have a few good legal principles, they come handy. But as we've seen in the Gabčíkovo case, they sometimes they're not extremely useful. And if you look at the history of the water allocation treaties, all these noble principles really hardly applied in reality. Normally, these allocation treaties are based on existing practice, renegotiation of something which has already been there. Actually, it may be an interesting thing to expand international water law to cater for this issue, but I think in reality, it's more about politics and power politics in a way than nice principles of water law.
Okay, thanks very much. We are a little bit behind schedule, but I think we have time for maybe 2-3 minutes. So what I wanted to do, we always look at what is the most popular question that is now raised in response to your presentations. So the most popular question is, how can we include local communities' voices in the process of negotiations and use it as a source of pressure to influence decisions? And that's also a question I like very much. And the other two popular questions, they've sort of been addressed already. So one is about who has a better chance, the upstream or the downstream state, and that was already addressed by Jimena. And the third popular question is about climate change, but we just had a webinar on climate change before the summer break. So I just wanted to ask the three speakers if they have anything interesting to say about the first question. So how to include local communities' voices in the process of negotiations and maybe in the settlement of disputes, because that's the topic of today. So if you have anything interesting to say about this topic, you now have the floor. Maybe I can ask Lingji first, and then Jimena, and then Gabor. But if you don't have anything interesting to say, that's also okay. Yeah? So Lingji first, please.
Thanks, Otto. I think for the principle of public participation, that's very important obligation to be implemented by the parties concerned in the decision making, in terms of environmental decision making, in terms of the use and protection of transboundary waters. But international law can only offer you a principle, like a general obligation. It will be implemented eventually by the party or the country that implement the plan measures. So during the planning phase, I think the law, the thematic law of that country, they shall be, incorporate and try to balance the interests of the public, especially the local population, the indigenous people population, and take them into account and consideration. Thank you, Otto.
Okay, thanks. Jimena?
Yes, I think that on the same line, as you see, in order to solve water disputes, in fact, you have different levels or different kind of rules. You have substantive rules, no harm, equitable and reasonable utilization. But in order to solve a dispute, you will need other rules to put on the table. For example, the procedural rules, as I already explained. And now with regard to the involvement of communities, well, I think that there, the most important rules are substantive and procedural rules coming from other areas of international law, in particular, human rights. So it is human rights law that requires that decisions taken by governments take into account the views of the communities that will be most affected by those decisions. So I think that here we need to bring rules from different areas in order to have an effective and also equitable decision regarding water disputes.
Gabor, do you have anything to add to that?
Yeah, certainly. My experience has been, and it's probably well documented in international literature as well, that it's not a very lawyerish answer, that most of these transboundary conflicts are driven by, or very heavily influenced by, national politics. It's a wound on the soul of the nation, all that stuff. Many of them are driven by unilateral actions, which are also again driven by national political agendas. And these national political agendas are mainly set by political elites and very often, in a very manipulative way. And basically, if you try to use the local communities who are actually engaged in the, who live there, you can actually get a better result. This is what we have tried to build up in the Gopchiko case in the past few years, that we tried to engage people and local governments and sort of the people who really were there for compromise and who live there, and for them it's something relevant on a daily basis, because they tend to have a more realistic take on the whole conflict. And if you manage to create a sort of an alternative narrative as opposed to the original, fist shaking, high rhetorics, about confrontation, it can influence, the sort of local perception of the conflict. And if there's more sort of normal talk in a way about the whole thing, unless it gets hijacked by high politics again, which always can happen. So it can be an exit option. So if we manage to pull down the level of tension by way of engaging, local people who are there who would like to make a compromise and make some progress, I think it's really helpful. It is something that we have actually tried to build up as a deliberate tool or a deliberate mechanism to sort of somehow deconstruct the high politics of the dispute.
Thank you. That was very interesting. But I now have to close the Q&A session, and I give the floor now to Yumiko, and I apologize for the couple minutes delay.
Thank you. Thank you very much for this really interesting panel discussion and all the presentation. Very, very rich. And I think we really learned a lot. Now we would like to move on to the breakout session. I know many of you still have a lot of questions, but don't worry, we have some time for you to interact directly with the speakers. So you can select the group that you want to go to. The group 1 will be Ling Chi Kung and Gabriel Baranyay, who is also from part of this Wuhan International Water Law Academy group. Group 2 will be Jimena Fuentes and Otto Spiers. And the group 3 will be Gabriel Baranyay and Barbara Janus Pauletta, who is the GWP's technical committee member. And then if you have, so these are the 3 speakers, and then the other chairs will help to facilitate the discussion. And if you have any general question about the MOOC or international water law or more in dispute settlement, more general questions, you can stay in this room to talk to Patricia Wouters and myself. We are a little bit running short on time, so we'll just have about 11 minutes of this breakout session. So please, now I think the breakout rooms are open. If you go to the right bottom of this screen, you will see these 4 dots in breakout rooms, and now you can see the rooms appearing. And you can just click to join. And if you don't know how to do that, you can also type in the chat the number of the group that you want to go to, and our technical host will help you to go to that room. So please join the group of your choice. I see a lot of people are moving. So yes, if you don't know how to go to the breakout room, please just type in the chat. So now, while people are jumping into the breakout room, here in the main room, it is Professor Patricia Wouters and myself. And if you have any questions to us, you want to say some comments, please feel free to open your mic and speak out. Pat? You also want to say something? You're welcome.
Okay, hi. I didn't see that we were in the groups yet. I was waiting for the groups. I just see this one big panel. Okay, good. Well, I would welcome anyone's questions on what we're doing at the Academy or the GWP MOOC or dispute settlement generally. It's so nice to see everyone here. I don't see, let's see in the view, who's in our group here. Oh my gosh, we have a lot of people here. Wow. Okay. Well, I wanted to say hi to Jean-Luc, who is our PhD student at the Academy. He's joining us from the Congo, I think, Kinshasa. Is that right? So does anyone have any questions in this group? Really fascinating topic, Yumiko, wasn't it? I wanted more from each of the speakers, and I wanted this breakout group to be longer. We always are back against the wall with the timing. So yeah. If anyone has a question, turn on your mic or raise your hand, and we can go with that. Does anyone have any questions?
Can I speak now?
Yeah, is that Ra Kefi?
Yes.
Okay, go for it.
And by the way, my name is Pure Water in Arabic.
Oh my gosh. Lovely.
Yes. So I'm Rawe, I'm from Tunisia, and I'm really glad to join you here. There is a lot of useful information, and I have like a general question. For example, from a legislative point of view, is it possible for a people of any country to sue another foreign country or a company belonging to that foreign country for environmental crimes or for polluting their local waters? Is that possible?
So you're talking about citizens in one country suing another country for, say, transboundary pollution. Is that the question?
Yes.
Yeah, well, in international law, as we heard Jimena say, it would probably have to be under human rights law or crimes against humanity. It's a very complex, very difficult issue, actually. So that is not covered. The dispute settlement we talked about today was pretty much state. We got into it a bit at the end. We were talking about public participation, but we did not cover that today. It's a highly specialized area, very difficult to do. And really we would need a lot of time to talk about that, Rowie. So it's possible, but very difficult.
Okay, thank you.
You're welcome. Any other questions? What kind of a shy group here today?
Hi, Pat.
Hi, Wuhan. How are you?
I'm good, and sir.
Good.
Yeah. My question relates to the principle of foreclosure.
Oh yes, okay.
And you know how I'm interested in that principle. In the context of the UN Water Convention.
Yeah.
And based on your experience, how does one basin deal with evasion of application of such?
What country are you from, Bokang?
I'm from Lesotho.
Lesotho?
Yes.
Oh yes, have we met in Lesotho even? Hi. Nice
you met in Dundee.
Oh, lovely. Oh, good. I've been to Lesotho. Lovely to meet you. Okay, so the question is, how do we deal with foreclosure? Well, Jimena talked about that, and I have very strong views. For me, the governing rule always is equitable and reasonable use. It includes no significant harm. And I think, the rules in international law are one, every state is entitled to an equitable and reasonable use. And so, you think about the upstream always developing last, usually the downstream will be developed. So then when the upstream wants to develop, you say, well, no, we're using all the water downstream. So, Salman has written, a couple of really monograph and a really good paper about, well, actually, when the upstream wants to develop, they should not be foreclosed from having an equitable and reasonable use. So if they need some water upstream and the downstream is using it already, like, that could be Egypt, for example, Egypt on the Nile saying, we're already using 110% of the Nile. We can't, Ethiopia, up to Sudan, you can't use any more of the Nile, but that's not the rule. The rule is equitable and reasonable use. Everyone gets a chance to put their case forward. All of the evidence, all relevant factors will be considered on this river at this time. So it moves in time, it changes in time. You look at the river now or the development now. So really, equitable and reasonable use means that each riparian nation is entitled to an equitable and reasonable use on this river, on this time for these uses. So that's how it's meant to work. Whether it works like that or not, my view on the no harm rule, the no harm rule is really more, what the UN Watercourses Convention says, it's a due diligence not to cause significant harm. So it's a duty of conduct. It's more a procedural duty where a state has to take all reasonable measures not to cause significant harm. So the duty is not don't cause harm. The duty is try your best not to cause harm. So the rule is, did that state try their best or not? It's not about whether harm is caused or not. Harm can be caused. Significant harm can be caused. The duty to be tested is conduct. So that's a big one. And if you read all of my work on this and my students' work on this, they get it clear. It's not no significant harm. It's conduct. did that state do everything possible? So in the context of downstream foreclosure, where you have new dams upstream, what you look at is whether the dams have been constructed in accordance with best practice to mitigate any harm downstream. So, Kang, I hope you're still there. I don't see you, but I hope that's helped. Has that helped?
Yeah, it did.
Good. Yeah, we're big on this. You know, equitable and reasonable use is the rule, and that helps upstream and downstream states. I think it's friendly to upstream and downstream states. I think if you read McCaffrey, he'll say that too. Okay, who else has a question?
Okay. Sorry. My name is India. I'm also from Lesotho.
Oh my gosh, Lesotho today. Yay.
Yes.
What's up, Natia?
I know that my colleague was asking that questions because of one of the issues that we are currently dealing with. We know that we share the same basin with the 4 countries, but when you get to South Africa, they have already even allocated water outside the basin.
Yeah.
But then when we try to develop upstream, they still claim certain amount of allocation, even though they have already allocated outside the basin. And though that allocation, of course, was done even before we had any agreement with them. So I'm just wondering how does that come to effect, or how does that affect maybe the negotiations that we have to have with them in order for us to be able to build new dams and then develop only the effect of the question that Tebogang has just placed of the foreclosure.
Well, you are entitled to an equitable and reasonable use, and it moves with time. The one thing I love about equitable and reasonable use is it moves with time. It's flexibility, and that's how watercourses should be considered. What's happening now? So what you have to do is get to the negotiation table. You absolutely have a right to an equitable and reasonable use. Downstream uses, they might have to look at reallocating. There is no priority of use for first use. You know, just because there's a prior existing use, that doesn't have priority in international law. In international law, it is one of the factors to be taken into account. So all factors, all new uses, the impacts of climate change, pollution, previous existing uses, everything goes on the table. We throw it all on the table now, and we try to reassemble the puzzle in a way that's fair and equitable for everybody based on now. So if it was me, I would say that I would go to the table and say, let's throw everything on the table now. Let's do some numbers. We have a right to use the water now too, because upstream was always lost to develop, and they should not be foreclosed from developing. That's what I would say.
30 seconds to breakouts closed.
That's clear. Oh, are we closed now?
Yes, thank you very much.
Not yet.
Okay. Any other questions?
Yes, I have my hand up.
Kosli, I don't see the hands up. Okay, Kosli,
okay.
Where are you from?
Yes, it's Kwetlisi from the Kingdom of Lesotho.
Okay.
Yes.
Oh my gosh.
No worries. Yes, I just wanted to know from an expert perspective, looking at the dispute settlement mechanisms, is there any preferable one?
For me, I always said, well, I like what Kong said. Kong is absolutely on the money. Preventive, dispute avoidance, and I would say fact finding. I would go with fact finding. So okay. I would start with, you know, institutional bodies, dispute avoidance, fact finding. I would not go to the court. It's too hard, too long, and sometimes too difficult.
Great.
That's what I think.
All right. Breakouts are now closed with everyone joining back the main session.
Thank you.
Thank you very much and welcome back. I hope that was interesting breakout session. I'm sorry that I know that time was very, very short this time. And maybe you were just getting started with your discussions, but I do hope that you really enjoyed it. And let us now hear back from just a final reflection from each of the panelists. Could I invite Ling Chi Kung?
Yeah.
Yeah, please. Please just give us a. Yeah, please just give us, you know, your final reflection after coming back from the breakout room.
Oh, the breakout room. We had a very good question about upstream and downstream country conflict. And the question goes like the downstream country had developed the water first, and then the upstream country decided to develop the watercourse, but it concerned its development might cause significant harm to the downstream country. So the question goes like, can the upstream country develop the watercourse by causing harm or damage to the downstream country? And the second gentleman gave me a very, very challenging question, asking about the quantity of the water that should flow naturally all the way from their origin into the sea, you know, intervened by human being. I didn't have a very good answer to that, but as a lawyer, I only can come up with the idea that it crossed the boundaries of international water law, the law of the sea, the law governing global climate change, or for the lawyer, we call it divergence or convergence across different sectors of public international law. Like all the elements of the environment, including human being, we have to find proper rules and basic principles to fix these challenging issues and problems. Thank you, Yumiko.
Thank you very much, Lingji. And on this last point that you made, you know, how do you deal with from the freshwater to the sea? If you're interested in this topic, please do come to the next MOOC session in October, because we will be very much touching on this very topic, on how to look at the source to the sea of international rivers and international water law. I would like to now ask Gabor to give your reflections coming back from the breakout and your final remarks, please.
Okay, thank you. We actually got started by the time we had to leave. I think the main question really was about proper mechanisms, so one size fits for all type of mechanism, the silver bullet for water allocation, and certainly we didn't get one. But it's a subject which is absolutely unexplored in Europe, because happily we have had the luxury of having enough water in most transboundary river basins, except for the Iberian Peninsula, where actually they have developed good mechanisms. But this is something I wish we continued with, and actually bringing good examples from non-European nations or basins to the EU.
Thank you very much, Gabor. And Jimena, would you like to give your feedback from the group and the final remark?
Yes, my final reflection would be that that water law and water issues is a very challenging area, because what I heard from the questions of my group is that in the end there are so many factors involved. Climate change, that's challenging in its own way. Politics, the interests of the communities, human rights issues, science, the needs of the general population in a country. So, and in the end, rules, it is true, they are applied and interpreted by governments. But I think that governments should be flexible, and agreements should be flexible. Agreements that are agreed today, probably they will be useless tomorrow. So governments should be open to renegotiate agreements in the years to come, answering to the questions that they will have to face in the future.
Thank you very much, Jimena. And finally, Professor Patricia Wouters, please.
Miko, you and I were in that. We had a great group. We had the same question about the upstream, downstream, the foreclosure of uses, and the meaning of the rule of equitable and reasonable use, and the due diligence duty. And I thought it was fascinating. And for me, I'm very clear, and you can look at the research of the Academy, and I welcome a lot more students on this topic. Equitable and reasonable use means everybody has an entitlement and a right and a duty at this time on this river to an equitable and reasonable use. So upstream and downstream doesn't really matter. No foreclosure based on the last to develop. Exciting. I mean, we could have gone on. I would really like to thank the speakers. I could have listened in another hour of each of them, and the participants, just fantastic. We really needed more time, Yumiko, but thanks to the members. I'm sorry we didn't get to all the questions, but it was fantastic. Thanks, Yumiko. Thanks, participants.
Thank you so much. And I know all of you had a very rich discussions, and you might have some more questions. In the MOOC, this open online course, there is a discussion forum in the module of the International Water Law. Please feel free to post any further questions there. My colleague Lutza is monitoring any questions that's coming up, and then she'll be able to liaise with any of the experts to get you an answer. So please utilize that platform that we have. So thank you very much. I would like to thank all of the speakers for great interactions and the great co-chairs for this session. So now I would like to just to take a little bit of time here yes, sorry. Next is the MOOC sign up. Of course, if you haven't signed up to the MOOC, please do sign up. Here is the links, and I think my colleague is also typing in the chat. This is now open until next year for 1 more year. And yes, we have a speaker, actually, Gabriel is speaking in this MOOC, and also today we also had Barbara, who has actually developed this international water law module. So thank you very much. And next, I would also like to say, please join our next event, which is on 19th of October. It's every third Tuesday of the month. So please remember that. We will have this topic of the source to sea approach in international water law. This very question of how does the rule of international water law, which is for the freshwater, and how does that actually interact with the governance of the marine interface? Obviously, it's very much affecting, the freshwater affects what happens there, affects the marine, and how does this work? So we'll get some discussion on that. And then in November, we are planning to have a water diplomacy and negotiation session on the 16th of November. And then I would also like to say next week, there will be the Water Convention's meeting of parties. It's one of the 2 key global conventions, as you know, and there will be some side events. There are a number of side events, but I'm just here highlighting the ones that GWP is engaged in developing. So co-convening, first one is here on the transboundary collaboration from source to sea, exactly on this topic on the source to sea. So this would give you a very good introduction to our October event. And of course, there is actually a lecture on this topic in the module 5 of the MOOC. So feel free to also watch that. And this is all on Monday next week. Another event is on the water, food, and energy ecosystem nexus in a transboundary context, also on Monday next week. And then finally, the Women, Water, and Peace, that is Tuesday next week. So please feel free to register this. Registration is still open. So thank you very much for this. And I know the time is running up. So if you need to leave, please go ahead. But please, if you can stay, if you could stay for just a few more minutes to do this final reflection together with us. And we are going to be using the same poll if that we have used earlier. Lisa, if you can show the poll if. Yes, it's coming. So here, if you go to the poll if, please answer these 3 questions. What have you learned from today's session? And this is an open-ended question. Just give us your feedback. And also, would you like to engage with other learners in a participant beyond these events or the MOOC? So we want to know whether there's any interest from your side on engaging in further interactions with the peers. We have a very little time today. And then the third question that we have is if we are interested in this kind of engagement, what type of engagement would be most beneficial for you. Could it be exchanging on understanding, getting to know about the job opportunities, showcasing the case studies, knowledge sharing, or networking, or any other? Please specify your answers here. So we just give you a few minutes. And of course, yeah, once you fill in, then you can submit the questions. And of course, sorry, the last question is on the other suggestions on what kind of engagement you're looking for. If you can just respond to this. So feel free to type in, but we will be actually keeping this poll open for a little while after the event. So if you would like to, it just really helps us to really understand. Yes, now we see the answer, some of the people answering what the job opportunities, showcasing case studies and networking and knowledge sharing. Yes, there's an interest in how people would like to engage. Yes. Yeah, please keep typing, and perhaps maybe I will just go to the final part of this event, which is a group photo. So we would like to invite all of you to turn on the camera so that we can all see each other and to wave each other and to smile with a big smile to take a group photo. And we may be using this group photo for any promotional purposes or on our website. So if you prefer not to have your face on our materials, yes, feel free not to turn on your camera, but we would love to see as many faces here for those who participated. I know you have been hiding, but been very, very active. Thank you so much. So yes, please smile. And now my colleague is taking the photos. So maybe you can also give a wave to everyone. James or Lisa, please let us know when the photo is finished. So maybe we all stop smiling then. Done? Okay, thank you very much. The photo is done. So now this concludes today's session. Thank you all for participating. Again, thank you so much to all the speakers, excellent speakers, Lingji, Gabor, and Jimenez, and two great co-chairs, Pat and Otto. Always a pleasure to work with you. And thank you, Dave and Barbara, for coming in to help us facilitate. And of course, our GWP team for a great organization of the event. And finally, and thank you to all of you who joined this event and staying until the end. We very much enjoyed interacting with you and look forward to seeing you next time. Bye. Thank you.